CRPIO on 30 January.
Okay, for what?
Also, Your Honor, I am the petitioner in the trial court. I'm filing a suit for eviction for my bona fide requirement. And somehow the defendant has filed a CR2 suit for the stay. And the final argument was on 17 January. The stage was for final argument. And the case was long than 18 August.
May it please your lordship. Your lordship, with due consent from other side, I beg to mention item number 19 of today's list, your lordship. Lordship, in this case, today only we have received instructions to appear on behalf of the respondent insurance company, your lordship. So I pray that your lordship, it may be taken up after 4 weeks, your lordship. In the meantime, we will receive the brief from the company.
You have taken consent from the other side.
She is appearing for the others.
Learned counsel, Miss
P. Bodhakur,
P. Bodhakur for the insurance company,
respondent number 1.
Respondent number 1, with the consent of the other side has paid for adjournment. List the what was your ground? What was your reason?
Today only we have received instructions to appear on behalf of the respondent insurance company.
Today to appear on behalf of the respondent number 1.
Lordship.
Who established the matter on?
After 4 weeks, any day.
After 4 weeks, all right. Heri, agor hitu ase niki? Agor listing or keba belek court Mitali Thakuria court asle gote. Court ketia fix korise ki antho ase niki? Antho nai no. Thik ase.
Obligation.
I'm paying for listing a FAO, my lord. But lastly, the new case, my lord, lastly listed on 21 January.
Last Mitali Thakuria Vientons asle. মানে নহলে বহুত কেস একেলগে জমা খাই যাব হেতুৱে এখন দি দিয়ে নহয় এখন দি লাইন থৈ দিবা বিও ৰেকৰ্ড খিনি আনি থৈ দিবা
I'm paying for listing an FAO, my lord. It was a new case, my lord, lastly listed on 21, my lord. But on that day, my lord, all the cases were deferred, my lord. There's some urgency. Can it be tomorrow, my lord?
Tomorrow? FAO tomorrow?
Yes.
At what stage? First date?
First date, my lord.
Tomorrow?
On listed 21, my lord, but all cases were deferred on that day.
Okay.
Tomorrow,
That is your lordship. Lordship, I'm going to mention 2 MFA listing on 4th February, lordship.
2 MFAs.
2 MFA forwarders.
On 4 years.
May it please your lordship. Lordship, I beg to mention a listing of an IA, lordship, which is arising out of an RSA 200 2017, lordship. Lordship, there is an urgency because the stay proceedings, so lordship, the execution proceedings has been already been in comments, lordship. So lordship, may please to list it on Friday, lordship, if possible.
ক'ব নোৱাৰো নহয় পাছবেলা মানে আনি থৈ দিবচোন পাৰিলে Okay, on Friday, all right.
Orders, lordship. Much obliged.
May I please, lordship? I beg to mention for listing of a CRPIO. It was on because stay is not there and proceeding is going on, and next date is on Friday in the trial court.
When do you want?
Friday
Next day is on Friday. You want it on Friday?
or Thursday.
Yeah, on Thursday.
Obliged.
May I please, lordship? Lordship, I'm paying for item number 16, my lord. This matter may be taken after 2 weeks, my lord, because file is misplaced in our seniors chambers, my lord. So this matter may be
More
taken.
pending case. Have you taken consent from the other side?
Junior is going to inform my lord. Otherwise, I may hear, my lord. No problem.
Can be heard. We'll wait for some time.
Yes,
Let your junior get the consent. If he gets the consent, then we'll defer
Okay.
it.
Oblige me.
May it please your lordship, I beg to mention item number 15 of today's list. I have already taken the consent from the respondent side.
Such an old pending case. And he has given consent.
Yes, lordship.
They go to some. Item number 15.
Yeah.
After some time, I'll check the record. You wait for some time. I'll hear them out, all the people who are sending to mention something. I'll hear them out, then you wait for some time, okay? Wait for some time.
May it be pleased, your lordship. Lordship, I beg to mention for listing one MFA in hearing column. Lordship, it's a old pending matter in the year of 2017. Lordship, matter may be listed on next Tuesday on 3rd of February.
Can be listed, yes, 3rd February.
Obliged, your lordship.
May it please your lordship, with due consent of the other side, I beg to mention hearing item 18, lordship.
Mm.
As the engaged counsel MS M. Chaudhary is not well. Kindly 2 weeks may be granted, lordship.
You have taken consent from the other side?
Yes, he is for the respondent.
What is your name?
S. Musahari, lordship.
Learned counsel Miss S. Musahari has submitted that the leading counsel Miss M. Chaudhary
Yes, lordship.
is not well. Full stop consent has been obtained from the other side. Place the matter. When do you want?
After 2 weeks, lordship.
After 2 weeks. 2 weeks?
Highly obliged.
May it please your lordship. My lord, I have the consent of the other side as well, my lord. Item number 23, my lord. My lord may not take up this,
No, you don't want to place this case before me, no?
my lord, because
Okay, I
senior
understand.
counsel, yes,
Yes. Senior counsel is Didas.
my lord.
Alright. Khalid, no?
My lord, K. Mohammed.
Huh?
K. Mohammed, Khalid.
K.
Mohammed.
Mohammed, okay.
Right.
Learned counsel Mr. K. Mohammed, with the consent of the other side, has prayed for adjournment.
My lord may take,
No, no,
not take
no.
up, not take.
Continue. Learned counsel Mr. K. Mohammed is present for the petitioner and learned counsel Mr. A. Gautam is present for the respondent. List this matter before any other court without me.
My lord.
Okay?
My lord, yes. I'm deeply grateful.
May I please, your lordship? Lordship, item number 11, record is not in enclosed record. So, kindly put the
Record?
for record
Item number 11?
11.
What
The enclosed
about
record
item
is
number
not in
11?
record.
Huh?
Enclosed the impugn order is not in record. So,
Why?
call for record.
Huh? Item number 11 to here? Oh. Here? Huh? Oh, আচ্ছা আছে এখানে দিয়া নাই Okay. You want a date?
No, lordship. Just call for record.
We'll call it, we'll call it. এইটো 1 মিনিট চাই লওঁ ৰ'ব। ইমান পুৰণা কেছ কেলে এজন বিচাৰি আছে জানো আছে নে? You have taken consent from the other side. You are for whom?
And for the petitioner.
Case number क्या है? K. Agarwal?
No,
Komal
lordship.
Agarwal?
On behalf of Mr. D. Mazumdar.
D. Muzumdar. You have a stay in your favor?
No, lordship.
No.
No.
There is an interim order. There is one interim order.
Lordship, I am not aware of that fact.
Proceedings of TX pending in the Court of Civil Judge Joharhat shall remain stayed, which is continuing till today. What is the reason?
Lordship, yesterday, Mr. D. Mazumdar's son marriage. So due to that reason, it is not possible for him to come today. Lordship may fix a short date.
Your name is
D. Devi.
Learned Counsel Miss Debbie, on behalf of Learned Counsel Mr. D. Mazumdar, has prayed for adjournment. It is submitted that consent has been obtained from the other side. Full stop. It is submitted that as son of Learned Counsel Mr. D. Mazumdar, as the marriage of Mr. D. Mazumdar's son was solemnized yesterday, today is not able to place his submission, full stop. The prayer for adjournment does not appear to be justified. A last opportunity is accorded to place the submission, list this matter on sorted legal.
Lordship, on that day, he will be out of station.
When will he be present?
Lordship, after 12th February.
Then 16 hearing no, 19 February.
Okay.
Positively for hearing without fail likhi diba. As this is a Komatadi, as this is an old pending visa.
Item number 1.
May I please have it?
You like to give?
Lord, in this case,
Are you ready?
my lord, I have come before this honorable court against the judgment and decree dated 27/4/2024, my lord. So the dispute basically in this case is with regard to the dower amount. Because the petitioner is claiming that at the time of his marriage, the dower amount was fixed at 51,000.
22/7/2024.
My lord. So that is the my lord impugned decree, my lord. No, I'm sorry, my lord, that 23/9/2024, that is page number 50, my lord. 23/9/20.
23/9/2024.
My lord.
Page number 15.
My lord. The operative part, your lordship will find at page number
Page number 15.
50.
50. No, not operative part. We'll start from
My lord.
discussions.
Yes, my lord. The discussion is your lordship will find, my lord.
52.
Page number 50.
52, where is that going there?
Yes, my lord, I'm reading it from page number 52, my lord.
Page number?
52. The second para will, my lord, reveal the facts in brief, my lord. That the plaintiff's case in brief is that the plaintiff on 19/9/2010 married the defendant as per Muslim religious rites and custom by executing a kavinnama, and the mohar was fixed at rupees 5,17,860 at the time of the marriage, The defendant paid an amount of rupees 6,350 out of rupees 5,17,860, and the balance amount of rupees 5,11,510 was pending, my lord. So that is the basically, my lord, the plea of the wife, my lord, the respondent. Now, my lord, paragraph 6, that says the defendant, when the defendant puts his case, my lord, the paragraph 6 says the defendant further stated that the Maharana of the marriage was fixed at rupees 51,000. So basically, with regarding, my lord, the dispute that the wife, the respondent hearing, she approached the court claiming that the dower amount was fixed at 5 lakhs, my lord, 17,860. And she has pleaded in her plain, my lord. And to that effect, my lord, she has laid evidence, and accordingly, my lord, after issuance of the notice, my lord, or receipt of the notice, the petitioner entered appearance before the learned trial court and also submitted his pleading, my lord. So for a moment, your lordship may be pleased to peruse page number 21, that is the title suit, my lord. Page number 21.
Why we will get the entire story in the judgment itself?
Because, my lord, of course.
You sit
So
down,
far
I'll
as,
read
so
the
far as
judgment.
the, my lord, my plea is
It's a
concerned,
very short judgment, I'll read it.
Yes,
Sit down for some
My
time,
lord.
I'll read it.
my lord.
Yes.
Yes, my lord. Now, that their plea is that the amount was, my lord, fixed at 5,17,860, my lord. And accordingly, they filed their sword as well as, my lord, the evidence. But so
They
far,
have proved,
process,
proved their case.
my lord,
They have proved their case.
my lord, they have proved their case, but my grievance is that, my lord. Somewhere they have said that the dower amount was fixed at rupees 5,17,000. Somewhere they have said it as 5,70,000, my lord.
Mm.
There is a contradiction. And moreover, my lord, that the basic contention between the parties was with regard to the, my lord, amount as well as the genuineness of the document, my lord.
Mm.
Because so far as the certificate is concerned, in the certificate it is written as 5,17,000, 17,000.
No,
so
genuineness,
and so.
you have questioned the genuineness of the document, not
Yes, my
them.
lord. Therefore,
You have
uh,
stated the document is forged.
of course, my lord. Then in that case, if the which amount to be believed, my lord, because in cross-examination, the PW1 says that the amount was stated in my presence, and that was 5,70,000, not 17. And the judgment also reflects like that, my lord. But they have not, my lord, applied for correction, or they have not said that yes, it is wrongly written. So that remains, my lord, unchanged. So that has also attained finality.
Have you given that exhibit 1? Copy of the exhibit 1 here?
My lord, exhibit 1 was produced by Jem, my lord. Because this
All right, what do
certificate,
you have to say?
yes, my lord.
My lord, his case basically was based on the complaint he filed before the CGM, my lord,
Mm.
that the cabin number was manufactured
Mm.
by the father of the, my lord, respondent wife and the Qazi. That case he did not pursue. That was dismissed for non-prosecution. Now, my lord, the amount has been proved by proving the cabin number through the Qazi as well as the attesting witnesses. There is nothing to, my lord, adjudicate by this honorable
Yes,
court
yes.
at this stage, my lord.
But
All the evidence, my lord, his evidence, even, my lord, the DW2,
17 and 70, maybe while stating, deposing there may have been an error. 70 and 17.
of course, that might be. But the fact is that it is on record, my lord. And they have not applied for correction. Number one. Number two, my lord, that
No.
if I alleged, my lord, that the certificate, the amount was forced and the certificate was manipulated, my lord. To that effect, what is the finding, my lord? Because there is no issue has been framed on that point, my lord. That is my question, my lord. It
What
was,
issue?
my lord, that whether the Kavinnama was manipulated or not. That was one of the fundamental issue, my lord. Material issue. So if your lordship is
Those
pleased,
framed.
no, my lord.
issue number 3, my lord,
Issue number-
page 59.
Page 55, my lord. for a moment, my lord, page 55. What are the issues framed, my lord? Paragraph 10, my lord. After going through the pleadings of both the parties, the following issues are framed by the learned predecessor. Whether the suit is maintainable in the present form.
Frame issue number 3.
This is with regard to the amount, my lord, but not with regard to the, my lord, the genuineness of the certificate. I have disputed the genuineness of the certificate, my lord, and it is my consistent plea in my written statement as well as my evidence, my lord. So that has not been done by the learned trial.
You see, this will include that issue.
Yes, ma'am. And that even
you
if
have
that,
also not filed any criminal case, and whatever you have filed, you have not pursued.
of course, it was
So
subsequently filed, my
this
lord.
goes against you.
Of course, but my plea, with all respect, my lord, suppose
You can come to an agreement and pay a lesser amount if you want, but not 51,000.
because for a moment, my lord, I want to take your lordship to one document, my lord.
What
That would also,
what is his profession?
my lord, he's a tutor, my lord.
Tutor.
Tutor. He is receiving only 12,600 salary, my lord, and he is paying, my lord, 7,000 maintenance to the present respondent, my lord. And that, my lord, it is although because it is written on record,
Salary as what? It's tutor.
tutor, my lord.
These are not salaries. These are tuition fees.
Yes, my lord. That is, he is receiving only 12,600, my lord. Because I have annexed, my lord,
What is he teaching?
my lord.
What subject?
My lord, actually, he was a PhD, my lord, but that he's serving in ME school, my lord, he's assistant teacher, my lord. I have annexed, my lord,
He is an assistant teacher.
my,
He is an assistant teacher.
my lord, annexure 1, I have annexed his, my lord, provincialization order, my lord.
And it's a page.
Page 19, my lord. At page 20, my lord, his name figures, my lord. At serial number 3, my lord, page number 20. And so far as the practice and tradition is concerned, a marriage in the year 2010, my lord, no marriage, so far I have the knowledge, my lord, dower amount is fixed at 5 lakhs or more, my lord. So far I have,
Teacher in a provincial school.
my lord, the provincial school.
What are you saying?
My lord,
He is not a tutor. He is an assistant teacher in a provincial school.
no, my lord. Serial number 3, my lord, the name and applicant designation is assistant teacher. The teacher, that is tutor, my lord. In the third column, serial number 3. Name and designation, my lord, name is, my lord, Jamaluddin Ahmed. Then designation is assistant teacher science. And the teacher or tutor, that is tutor, my lord.
He has another family now.
Yes, my lord. He has another family. And one baby girl is also born out of his second marriage, my lord.
So how much you are willing to pay as dower?
Dower perhaps, my lord, is not negotiable, my lord. The
I know.
dower amount, my lord.
I know, not negotiable.
Actually, my lord, that I have been activized in this case because the dower
But
amount.
you see, you cannot take so much of benefits also at the same time.
My
You are
lord,
receiving 7,000 per month as monthly maintenance.
my lord, the maintenance amount can be negotiated, but the dower amount perhaps.
So why
not
don't you
negotiable.
negotiate it
Ma-
before
my-
admission? Why don't you negotiate it, maintenance amount? Then he will pay the dower
I have
amount.
no instruction regarding the maintenance amount, my lord. I have no instruction. I will have to take instruction on the point of maintenance, my lord. But
There will
dower-
come-
No, even from the written statement,
No,
it
you-
transfers, my lord.
See, just a moment. See, he is an assistant teacher. I know how much they draw. They draw a very handsome salary.
my lord, he is a BSc. He has to do, he can do
I know.
anything else also, my lord.
No, my
Private
lord.
tuitions, I know everything about them. Private tuitions, I know very well.
My lord, page number 20
No,
is
just
my
a moment,
provincialization order, my lord.
Just a moment. He will take instructions relating to the maintenance. So if the maintenance, she can adjust with the maintenance, then maybe then you can pay the remaining more. You have
My-
paid only 20,000 or something earlier. 20,000 or something. Out of 5 lakh, 17,000, I think you have paid 1 lakh or 20,000 or something, as goes the story.
My lord.
6,000 something he has paid.
6,000.
Dower amount only 6,000, my lord.
Okay, 6,000 you have paid.
My lord.
So then you can pay the remaining part of the dower amount and then little bit of settlement in the maintenance amount. Let him obtain instructions.
My lord, I also obtain instruction as to his salary or remuneration for whatever may be. I also
Not
have.
required, I know.
My lord.
Not required. I know very well.
No, my lord, because I'm a tutor, my lord, not assistant teacher. The provincialization order itself says, my lord. That, my lord, the pay scale.
All right.
My lord. My lord.
You can obtain
My lord.
instructions. Then we will fix this case on next date, within this week?
My lord.
Can you obtain instruction within this week? Okay. Learned Counsel, Mr. A.L.
AL.
And Learned Counsel, Mr. Your name?
I.H. Sakia.
I.H. Sukia,
I.H. Sakia.
have submitted that they will obtain instructions from the petitioner as well as the respondent. List the matter on a haftatar video.
30,
On 30.
but can it be on 29, my lord?
Yes,
Or-
can be on 29. On 29, yes. You will obtain instruction
Right.
and for hearing day, we will
Right.
dispose it off.
My.
Obliged.
Obliged.
My name may be shown. My name has not been shown.
Registered to reflect the name of Learned Counsel, Mr. I.S. Yogia in the cause list as Learned Counsel representing the respondent.
Mine. Obliged.
I'm obliged. My lord, in this case, I need some more time, my lord, to file my reply. They have filed a petition for substitution, my lord.
Okay,
Someday.
okay, any problem? No. Learned Counsel, Mr. G. Uddin,
Yes, ma'am.
representing the respondent has submitted for some time to submit his reply.
Yes, my lord. On the IA, my lord, they have filed for
In the
substitution.
IA, filed by.
Is there, my lord.
Delay of 608 days for substitution of the appellant number 2, Lordship. So they want to file the
In the
written
I-
objection.
Yes.
Okay, what objection or substitution?
No, there is a delay 600 some days, my lord.
Okay.
608 days.
Against the against the IA filed by the petitioners. Learned Counsel, Miss
S. Todi.
S. Todi is present for the present on behalf of Learned Senior Counsel, Mr. G. N. Sahelwala, representing the appellant.
Obliged, Lordship.
Obliged. Yes, thank you.
My lord, service is complete, my lord.
Mm.
And CCR come, my lord, let the matter may be heard together, my lord, item number 3 and
3 and
4.
4, okay.
Yes, my lord.
Lordship, hearing is okay, but regarding we have filed an one IA for withdrawal of the 2,50,000, which they have
We
deposited.
have no
That may be-
objection, my lord.
The IA from the IA just. IA number?
Lordship, it is not reflected. It's filed on last September.
111, IA 111.
You দিয়া নাই না আজি?
We have deposited amount, my lord.
আজি fix কৰা নাই?
Lordship, then it may be fixed. Because as per the order dated 27/2022, it was directed to deposit 2 lakh, and they have deposited on. No.
Is there any order for withdrawal? No.
Yes.
No,
No
no,
order.
no,
No.
my lord.
Perhaps the I is not
They may
No,
withdraw, my
yes.
lord. We have no objection, my lord.
No, but it has not been listed today.
Yeah.
Yes, ma'am.
So we'll fix it for hearing. On that hearing day, we will allow the IA.
Yes, Lordship.
They may also check with registrar.
No, the I is not
Because
numbered.
I
They
is
have
not-
withdrawn or
I
not,
may
my
come
lord.
up for order.
Then it will come back to our orders there.
Yes, Lordship.
It will come back to orders.
Yes.
Obliged.
Pleadings are complete. IA number, how much to be listed?
Amuru Sopna.
Parties are represented. Pleadings are complete. IA number, you do not know, na? IA with prayer for an interlocutory application was filed by the claimant, which is not listed today. List the interlocutory application for withdrawal of the
Deposited amount.
deposited amount. Withdrawal of the
Registry.
amount by the claimant, which was deposited by the insurance company.
Okay. Obliged, ma'am.
Kindly amend.
Date na like, date. List after 2 weeks. Nine. এই তেখেতক মাতি আছো ছমাহ মাতি আছো ছমাহ You were asking for an adjournment, no?
My lord, I am appearing on the respondent severally for government.
No, no, you were asking for an adjournment or you were
My lord, we have taken consent.
consent, which one?
Yes, Item number 16, hearing list, my lord.
Learned Counsel Miss L. Sharma,
Yes,
with the consent of the other side, has prayed for adjournment. List the matter
after 2 weeks, my lord.
after 2 weeks for hearing positively without fail,
Oblige me.
comma, as this long pending case. Item 16 now. Item 16 there. Item 5 কোনো অহা নাই নেকি? Appellant is not represented today. Is this matter after 2 weeks?
Yes, my lord, I am appearing on respondent 7 and.
Okay, okay. Learned Counsel, it appellant is not represented today, comma, Learned Counsel, Mr.
7 and
Your name?
S. Dasman.
As Das is present for respondent number 7 and 8, list this matter after 2 weeks.
May I begin, Lord? As per office note dated Lordship 26/11/2025, Lordship. Answer notice upon the respondent number 4 and 6, Lordship. Sometime may be granted, Lordship. Okay.
Lordship, may I point out, okay? After getting the stay order on 1st of August, they have not taken any steps on the other respondents other than 4 and 6. 4 and 6 has already been expired. They know it very well. I have filed, this is a decree for execution of the decree. 47 petition they have challenged, which the suit was filed in 1990. Decree was granted in 2000, then first appeal, then second appeal affirmed by the Honorable Guwahati High Court. On the same grounds that suit is not identifiable, they have filed the 47. Same was dismissed, and now they have before this CRPIO, Lordship. Since 90, I am fighting for my rights, Lordship. And they have implemented the 4 and 6, they have already expired. They know it very well. 4 and 6, and they have not taken steps for against any other copy has not been furnished to us also. Even
Furnished, Lordship.
What is the problem?
Lordship,
Why haven't you taken step,
we have to receive, Lordship.
after stay order?
Second, Lordship.
Note sheet is clear, Lordship. They have taken steps only on 4 and 6 who have already been expired. No steps against others. Immediately after taking steps, they have to take steps on all.
1/8.
On 1/8, issue notice, then next order, I have appeared. And they have, thereafter they have taken only on 4 and 6, who have already expired. And someone have been returned with report that 4 and 6 has expired. They have expired in year 2020. One Amiron, Aimona Khatun, Aisa Khatun got it. And Amiron also died in 2020. Honorable High Court has confirmed the decree on 2015 RSA in RSA. Again, on same ground that suit is not identifiable, they are not in possession, which have been dealt by Honorable Guwahati High Court in the RSA. So let them substitute, no problem, but a short date may kindly be fixed, or stay should be vacated also.
If you want to step, I will vacate the stay, definitely.
Lordship, I follow my senior.
Huh?
Sometime may be granted, Lordship. My senior is another.
Who is your senior?
AC Somani, learned senior counsel.
Okay. After some time. Or else you can inform him that if steps are not taken,
Second, Lordship.
no, not against the others, if.
No, they may give me a copy now, I have no objection on that, but what's about the death persons, Lordship?
Are taken,
They-
we will vacate the order.
They have
I'll
filed
fix an
the,
order like
I
that.
call my.
they have filed the case against the death persons, Lordship. Knowing well that 4 and 6 has already been expired in 2021.
knowing it well, because that matter has been reported to the executing court during pendency of their petition under 47.
Just a minute.
All right, we'll wait. 6 to অকমান দেৰি ৰখাই থৈ দিয়ক।
Lordship, as per the office note dated 21/2026, LCR has not been received. As per the last occasion, LCR was called. Appeal was admitted.
Lordship, I am appearing for respondent number 4.
Everybody is present, no? Only we do not have the LCR.
Lordship, I am appearing for respondent number 4.
And,
I'm appearing for respondent number 1 to ensure.
yeah, so everybody is present, I think.
Yes.
We have only 4 respondents, I believe.
Yes, bro.
Lordship.
Okay, we'll wait for the LCR then.
Lordship. After 2 weeks, no.
After 2 weeks. 4 only, we have 4 respondents.
Lordship.
Learned Counsel, Mr. K. Brook
Okay, bro. Lordship.
is present for the appellant, comma. Learned Counsel, Miss
P. Bodhakur appearing for respondent number 4.
P. Bodhakur is present for respondent number 4, and Learned Counsel, Mr.
S. Bathari.
S.
S. Bathari.
Bathari.
Read.
S. Bathari is present for respondent number 1, 2, and 3. Full stop. Trial court records are not received. Issue reminder to forward the trial court records immediately. List the matter after 2 weeks.
Obliged.
Thank you.
Kindly allow us 3 days time to take steps on all the respondent, my lord. Order was passed on last month of December, my
But
lord.
you didn't take steps.
No, my lord.
Learned Counsel, Mr. L. Farma is present and has submitted that steps will be taken within 3 days
3 days. my lord.
to issue notice to the respondents.
All
List
the
the-
respondent.
huh?
All the respondent.
To all respondents, list the matter after 2 weeks. Steps to be taken within 3 days from today.
Oblige me.
To issue notice, steps to be taken within 3 days from today to issue notice to all the respondents.
May I please, Your Lordship? Your Lordship, we have filed one IA for early hearing, Lordship. This IA is for early hearing, Lordship.
Not have any objection to early hearing.
Okay, we'll allow it then. Try to put goal Jackson. Early hearing or can I at a decent.
Item
853
853.
of 20.
Oh, it will. Okay. Learned Counsel, Miss
B. Hazarika.
D.
B. Hazarika.
B. Hazarika is present for the applicant. And Learned Counsel, Mr.
TL Oscar.
P.
TL Oscar.
TL
Oscar.
TL Oscar is present for the respondents. Full stop. This application is filed under section 151 of the Code of Civil Procedure 1908 with prayer for early hearing of RSA number 59 of 2019. Full stop. As the appeal is an old pending matter, comma, the IA is allowed and the appeal RSA number 59 of 2019 is fixed for early hearing on date
Second week of February. Any date, Your Lordship.
reduction second week of February.
12th.
February 2026 positively without fail. In terms of the above observation, this IA stands disposed of.
DPO.
Appeal to আছে নেকি? RSA. Parties are represented, leave this matter for hearing on কিমান কৈছিল 12 February. 12 February. Positively without fail. Appeal to.
Your Lordship, as per office note dated 21/1/2026, the notice has been issued to the respondents. The service is still awaited.
Your name?
M. Chettian.
Learned Counsel Ms. M. Chettian is present on behalf of Nalai is present here. Is present for the applicant. Office note dated 21/1/2026 reflects that service report on the respondent is awaited. List this matter up to 2 weeks. Alright, 2 weeks leave eligible.
My reason is I'm for the appellant Millard and they have filed an application for now injunction after Millard about 6-7 years. So Millard, my prayer will achieve they have filed IA and IA Millard was defective and as for office note Millard that
For I, my lord, I have filed for actually injunction because, my lord,
Proceed,
after
yes.
the date of this appellant, my lord, they are disturbing our peaceful possession. On the basis of the, my lord, order in the Lordship may kindly peruse the stay order, that is the stay of the judgment passed by the Honorable Civil Judge, Nagaon, my lord. That was stayed. But on the basis of that stay order, my lord, they are disturbing our peaceful possession. We are brother and sister, no problem.
Yes,
But
sir. Ek minute. He is denying.
my lord,
He is denying.
now my other prayer is will receive that the LCR has come. Matter is 8 years old now. So let the matter dispose of whole matter, then it will be very, very better.
Then when should we fix it?
Next month, Millard, any date, Your Worship, or this month?
2018 matter, my lord.
8 years.
Secondly, I am for the respondent, my lord. What happened? There was no any issue. The appeal was filed.
That
After
will be-
The main order is in your favor.
That
Yes,
will be-
yes.
Let us dispose it then.
Yes.
He is denying also. Let's see. Let us dispose.
Herbal denial, they let them file their objection if any, my lord. Herbal dealing, what happened? They're enjoying the property now. I'm equal owner, but they have been dispossessed our.
On
They
12
cultivable
February,
land,
let
my lord,
them
and
dispose.
they are, my lord, trying to sell it.
See,
out.
we will try, we will, for once at least we will try. Let us dispose it if not possible on 12 February. If
12
not possible, then it will come back to orders again. Then
Okay.
dispose of the IA.
Yes, yes.
They will file their objection there then,
Yes.
there and then.
And moreover, Millard, there is IA was there is a defective and again they have filed that.
No, my lord, what happened?
That is not there on the official
No,
only seen.
the IA, I have
Not there.
in the IA, my lord, one order was passed on the same date. Instead of, my lord, IA order, I have this clerical mistake. They filed the main order. The main order of the RSA instead of IA order, same order. In the IA, there is a stay order, but wrongly annexed the main order. It should have been, now they have corrected, because they have filed the IA order, which I am now challenging for modification only.
Let the matter come on 12 minutes for final disposal if possible, Millard, then it will be.
12 of
Well,
February.
Both parties are represented.
My lord, we
Yes,
are
yes.
applying is for the respondents.
Learned Counsel Mr. R. Bhattacharya is present for the applicant. And Learned Counsel Mr. A. Roshid is present for the respondent. Full
No,
stop.
I'm for the appellant.
Appellant, he is for the
In
appellant.
IA, you are respondent, no?
Yes.
Yes, I am,
Yes.
yes, ma'am.
IA to Lihiba is present for the respondent. It is submitted that this IA may be taken up together with the appeal for final disposal. Final and speedy disposal. Full stop. RSA to Lihiba, both the parties are represented. List this matter for as stop declare, list this matter for hearing on 12 February. Huh?
Yes.
দুইটাতে লিখি দিবা, huh? List this matter on 12 February.
Obligation.
Mm.
In this matter, answered notice upon the respondents in IA is for condonation in preferring the regular second appeal, 1261 days, Lordship.
Notice.
Yes, Lordship, await service report. Notice
So-
already sent.
Oh, service report.
As per office note dated, the service report is awaited, Lordship.
No such person in the address, incomplete address, address he left RTS. What is RTS?
Return to sender.
Oh, return to sender. Okay.
Maybe there is a address is maybe wrong, Lordship. So for that only return to sender.
6/1/2026. R1 no person in the address.
Lordship.
R2 incomplete address.
R1 we have to verify.
And R3 addressee left, hence RTS.
Lordship. So we have to verify all the addresses and thereafter we have to file an amendment application
I think so.
for change of address. I'll take instruction and then Lordship I'll proceed.
Learned Counsel Ms. R. Chaudhary is present for the appellant stroke applicant. To stop. Office note dated 6/1/2026 reflects that the notices served to R1 has been returned with a remark that no such person in the address within inverted commas no such person in the address, comma, to R2, next line to R2 has been returned with a remark that address is not complete, and to R3, next line to R3, returned with a remark that within inverted commas addressee left, hence RTS. It is submitted by the learned counsel for the applicant that she may verify the address and take further steps. List this matter after 2 weeks, okay?
Lordship. Lordship, I'm sorry, in item 5, I could not remain present. None appears, Lordship. If your Lordship record my presence on
Okay.
item 5, Lordship.
Okay. Item 5.
Await service report in that matter also.
Okay. Who knows item 5 was? Oh, it take code person. Our presence to our service report awaited to type codable code.
I deeply apply.
Oh, 6/2. Oh, timing আছে নেকি? দি
Ending 6. May I present? Lordship, my learned senior friend has informed that respondent number 4 and 6 has died. This information was not to my knowledge. Now, so far, my respondent number 4 is concerned, his legal heirs is already on record. So respondent number 4 name may be strike out, can be strike out. And 6, my learned senior friend has provided me the names of the legal heirs. I'll file an impletement application for in the revision petition because I have to implement them. Otherwise, it will be infractions.
It has already been awaited. It's long back 2026 died. I have given the date. Lordship, let them implement. I have no objection. A short date may can live. Yes.
You're Bhardwaj, no? You're not Sharma.
Not sir. Bhardwaj.
So appearing for Sharma.
AC Sharma is.
Learned Counsel Mr. What
G. Bhardwaj.
G. Bhardwaj is present on behalf of Learned Counsel Mr. AC Sharma. And Learned Counsel Mr. SK Poddar is present for the respondents.
Except 4 and 6.
Respondents?
Except 4 and 6. All except
Respondents, except respondent number 4 and 6, full stop. It is submitted by the Learned Counsel for the respondent, for the appellant stroke applicant.
Petitioner.
Stroke applicant stroke petitioner.
Yes.
Applicant stroke petitioner that the legal heirs of respondent number 4 are already on record and their names and thus the name of the respondent number 4 may be struck off as the respondent number 4 has passed away, full stop. Further time has been sought to implement the legal heirs of respondent number 6. Which is allowed. List this matter after 2 weeks.
2 weeks.
2 weeks.
the date may can live.
List this matter on data 2 weeks of data 17 February or list
So
this
the
matter on
interim order
17
passed
February.
earlier may be come.
Okay, interim order passed earlier shall continue to the next list.
Hello.
IA for withdrawal of 50% deposit awarded amount, Lordship, which has been already deposited by the appellant side, Lordship.
May it please your Lordship, we may be given 2 weeks time to file our objection, your Lordship.
What
We have
they
objection.
are want to withdraw the 50%,
they can, the,
Regarding withdrawal, your lordship, we have
The-
objections, so we may be keeping 2 weeks time.
What kind
the
of?
IO can be dispersed on the, with the
Lordship,
condition that the.
We are denying
petitioner-
liability, your lordship. No premium was, extra premium was paid for covering the risk of the person who was traveling as a gratuitous passenger, your lordship.
So IO can be dispersed with the.
The vehicle was a
condition
goods
that
carrying
the-
vehicle and it was used for cultivation purpose and there were no extra premium was paid for covering the risk of the person, your lordship.
That will be.
He was
decided
traveling as an
carrying ship.
unauthorized person, so
Lordship,
your lordship,
that-
that
that-
is the ground, your
That
lordship.
IO can be
Your lordship,
dispersed with
next
the
time,
condition
your
that
lordship, my prayer is that this petition may be heard after filing of our objection, your lordship.
this IO may be disposed of with the condition that the 50% deposit will, the withdrawal, after the individual subject to the deposit, individual bond lordship, that can be lordship. If they succeed their case, they will return their 50% deposit money lordship. Subject to the individual bond lordship, they will withdraw their amount lordship. That can be lordship.
Lordship, I pray that your lordship, we may be given a week's time to file the objection.
And award
1
will
week?
grant.
1 week, your lordship.
They'll file a short objection. This type of petitions are allowed, you don't.
Lordship, why they are wasting their time, lordship? They file a appeal in 2024. lordship.
Usually this type of petitions are allowed. Let them file, let them,
Lord.
we must
Finally,
hear
date may be
both
fixed.
sides.
That date may be fixed, lordship.
Learned counsel, Mr.
Lordship, I am on behalf of respondent number 5. Lordship, we have appeared for the first, this is our first
Owner, no?
appearance.
You are for the owner.
Yes,
Owner.
owner. So Lordship may sometime may be granted.
Learned counsel, Mr. B. Islam
Lordship.
is present for the petitioner and a petitioner, no, applicant likha, is present for the applicant, comma, learned counsel, Miss R. Usam is present.
Miss
for
P.
the applicant,
Bothakur.
or Miss P.
P.
Bothakur.
Bothakur.
Miss P. Bothakur is present for the insurance company and learned counsel, Miss
B. Shaha.
B. Saha is present for the owner.
Number 5.
Full stop. Miss P. Bothakur has paid for time to file objection, list this matter after 1 week. Huh?
Date
1
finally
week?
be fixed, lordship.
Date
Finally.
can just 1 week. This matter after 1 week, what the date this is? On 16th? 16th? On 16th.
Okay.
Possible.
Item 14.
Amen.
Item 40.
Applicant is not represented, leave this matter after 2 weeks.
Person, this appeal is on a ground that section 163, it was filed, it is an application filed under section 163A. Now it's converted to amended to 164.
Okay,
Yes.
SB এখন ডিপোজিট দিল।
It is a structured compensation. Let's say earlier, now it is fixed 5 lakhs. Earlier, it used to be dependent on a particular table was there. From the table, the company.
5 lakhs, no?
Now it is 5 lakhs. So Lordship, what has happened in this case? That apart from
No, no,
that
Motor Vehicles
compensation
Act-
under 163A.
Amendment খন একদম নতুন খন। দুখনমান আছে amendment খন। 2019 হয়, তাৰ পাছত। The new amended act is after 2019, no?
2019.
It will apply to the old one. The case is of 2018.
2018?
Lots.
Sure?
Sure. Lots.
Okay. হ'ব 2019 খন দিলেও হ'ব। ন এইখন দিলেও হৈ যাব।
The objection that I had raised at that point of time, Lordship, it was an application filed under the unamended, previous act clause, is that certain heads of compensation have been allowed, which is not applicable to section 163A. Since its structured compensation is limited, and even in certain heads of pain and suffering, 5,000, medical expenses, 15,000, it is very limited. It is meant to be limited. There is originally the objective was not to proliferate it horizontally or even vertically. It is fixed compensation. So what was given in this case, Lordship, is loss of consortium of rupees 2 lakhs, 1 lakh and 50,000 is for it. That was not there. It's not a part of structured compensation. Then rupees 20,000 towards funeral expenses, 25,000 towards pain and suffering, and rupees 25,000 towards love and affection, Lordship. These heads are not applicable to structured compensation, section 163A. Even medical expenses of 2,22,000, 20,000 was allowed, whereas the maximum compensation allowed under the head. It is a legislature that had made it fixed. It was not thought of. It was thought of, and still only 15,000 was given. Now I don't think any court has the mandate to go beyond the structured. It's a statutory provision. I don't know if any court has the mandate to go beyond the statutory provision. In 166, His Lordship, it will depend on the facts of the case, merits of the case, and maybe any kind of compensation can be given. It's a fixed compensation and statutory under 163A. I don't think it can be touched by any. Now that has become 164 now. Now question is, Lordship, whether some judgments which has not considered this to be prospective in nature, retrospective in nature, in the sense that it's applicable to even cases which were filed beyond the amendment, even before the amendment. This is a kind of this amendment was brought in by way of substitution. When an amendment is brought by way of substitution, then it's like as if the previous provision did not exist. As if this is the provision that had been prevailing from the beginning, ab initio. So for all purposes, it will now be, in my humble sense, 5 lakhs. It's fixed, and that is retrospectively applicable. There are judgments to that effect, Lordship. I have several judgments showing interpretation of the word substitution. When an amendment is brought, when it's said instead of inserted, it's substituted. When it's brought by substitution, then it becomes retrospective, as if the previous provision never existed. These judgments are there, Lordship.
Then it will become prospective.
It becomes
Previous provision were
normally,
not existed.
Lordship, amendments are prospective, but only rare cases it becomes retrospective, and it all depends on how the amendment is brought about. Here the amendment is brought about.
Provision is not applicable. If previous provision is not applicable, it will become prospective, not retrospective.
It becomes Lordship retrospective. It is as if the previous provision never existed.
Okay, never existed. As
It
if
means
the
that
previous
it didn't
provision
exist.
never existed.
It as if this is the provision that was there from the beginning. That's why I'll substantiate
Understood,
my.
understood. Now I understood.
Yes, Lordship. So this becomes retrospective in nature. So all taken together, now the Act says, the amended Act says, it's 5 lakhs straightway. Regardless of the age, regardless of income, it's fixed 5 lakhs for everybody. Even if the victim is a 5-year-old or a 50-year-old, it would not make any difference. It's 5 lakhs. Similarly, whatever, regardless of the income, it is still 5 lakhs. So that is my submission. These heads of compensation, Lordship, would not.
You want the quantum to be reduced?
Yes, Lordship. The award was 5 lakhs, 10 lakhs 76,000. I'll just see the award. 10 lakhs 66,000 was the award, Lordship. But in my humble estimation, it should be now straightway flat. One reads the provision of section 164. Nothing is given beyond 5 lakhs.
According to you, it will be according to it will be according to the provision before the amendment from J. Kolita.
Lordship,
Huh?
What my learned friend is submitting regarding the applicability of prospectively or retrospectively. Law is settled by the apex court that if there is specific provision incorporated in the amendment act that this act will be effected from retrospectively, then it will go at retrospectively. Otherwise, every act to be implemented subsequently, it will prospective. So there is a settled law. If law is declared, I can submit loss of judgment. If there is no specific provision regarding the applicability of whether it will be applied retrospectively or prospectively, then it will be prospective. There is no question of retrospective. First thing. Second thing is that, Lordship, what my learned friend is submitting regarding the quantum that has been awarded by the learned tribunal is there. See, the concept of the future prospect and the present price hike of this present situation. The Supreme Court is the catena of judgment has held. The law held in the 1994, that should be modified by the parliament, but the parliament is not taking care of this issue. They are sitting over last more than 2 decades. Therefore, the Supreme Court in different judgment has held that the quantum, the amount mentioned in this schedule 2 regarding the future prospect and all, that should be modified to the considering the facts and situation of the present situation. So now in the different judgment, court has held that it should not be stick on the amount mentioned in the schedule. It can vary depending upon the situation. So accordingly, this case was of 2018, and what my learned friend is submitting regarding 1994. So after about 25 years, this question of consideration of this case has come on. Therefore, the learned tribunal has rightly held and awarded the compensation regarding the loss of dependency is correctly held as per the schedule. Future funeral expenses, this also 20,000 is awarded, and pain and suffering 25,000, and loss of consortium. Loss of consortium, even the learned tribunal has given lesser than up to have been given, because there are 3 dependents. The first one is claimant number 1 is wife, 2 is the daughter, 3 is also daughter. So considering the pronounced judgment, the consortium should be 45,000, 3% enhancement. After 17, it will around more than 150,000. So tribunal has awarded only 1 lakh. And regarding this applicability, just I am going to one judgment only of the apex court lawsuit. This is held in 2022.
See that there are 3 persons.
Yes.
Then consortium will be
Consortium should be
40,000.
48,000 into 3. Yes.
40,000 into 3.
3.
It will be 1,20,000.
So, we have been given only 1 lakh.
2 lakhs, no?
No loss.
No, yes. 1 lakh plus 1 lakh plus 25,000.
That is different heading.
It's all
Consortium
25.
is 1 lakh. Consortium is 1 lakh. So
1 lakh is also for 1% or 3 of them?
3.
For 3 of them.
3. That is why I am saying lordship.
The next head is lordship, loss and lab, and it is not applicable.
Loss of, no, lordship.
Loss on?
Loss of lab and application under 1 lakh has been given. Now, very clear judgment. When loss of consortium is given, loss of love and affection, that is there's no place for that. There's no place for once consortium is considered, love and affection, that 1 lakh will just lordship go.
The concept of consortium and love and affection quite different laws that cannot be clubbed together.
So you see in that Pranay Sethi case,
yes,
on a Sethi's case, the heads were very clear.
Lordship.
No love and affection.
No love and affection.
But other different judgment lordship, there is there. Pranay Sethi, after Pranay Sethi judgment lordship,
there is no judgment that gives love and affection.
Lordship, there is judgment. Yes. For Pranay
there
Sethi
is no
also
judgment.
lordship, although we are
Consortium for children were allowed by that
Pranay Sethi judgment there.
Agarwal,
Lordship,
Sushila
filial
Agarwal's
consortium,
case.
spousal consortium, and lordship this 3 consortium, 3 headings is there.
And one more case was there, that I forgot that case. That latest.
Magma.
Huh?
Magma case, yes, Magma case is there. That is also considered the Pranay Sethi judgment. So all these cases has been lordship relied upon by the tribunal lordship, and tribunal has rightly arrived into a finding.
No, you see, it's okay. It's okay. We will
Yes.
consider Magma, Pranay
Yes,
Sethi, everything.
yes.
But the core question is that whether the structured
There is no
Composition
bar.
can be changed. That's
Lordship, there is no bar. Just I am relying upon the judgment of the court also.
we will go to all these details that Pranay
Yes,
Sethi and Magma and all this,
Yes.
we will go, but whether which one?
Lordship, this is of 2021 1 SSC 317. Just I am just pointing out the paragraph number 14, 15, 15.
It's one Ansari.
Yes, Lordship. Parvan Anchal,
Paragraph?
Lordship. Starting from paragraph 14, Lordship, and
Please read.
relevant Lordship will find at page, paragraph 16, page 3 to 1.
Okay, please read.
Yes.
Hmm.
In view of the above, we deem it appropriate to take national income of the disease at rupees 25,000 per annum. Accordingly, when the national income is multiplied with the applicable multiplier of 15 as prescribed in Schedule 2 for the claims under Section 163A of the Motor Vehicle Act 1988, it's come to a so-and-so multiplier towards loss of dependency. The appellant also entitled to a sum of rupees 40,000 each for filial consortium and 15,000 each for funeral expenses. Thus, the appellant is entitled to the following amount. So loss of dependency Lordship, it is applied considering the multiplier. The filial consortium 2 is there, so 40,000 to 2. Funeral expenses is Lordship 15,000 is given. So Lordship, there is no bar. Apart from this judgment, there are lots of judgment Lordship. Court has given the defined heading, defined quantum. So the concept for my learned friend is submitting that only 15,000 will get in as per Schedule 2. So Lordship, that cannot be considered at this stage because in different judgment has Honorable Court held that. So it is of 1994, this enactment of 1994. So it is very
98, I think.
88 Lordship. Subsequently 194 is there.
Yes, yes.
1994 is there. Subsequent amendment.
Yes, yes.
So that is there are different judgment laws directing the Parliament to Lordship modify the relevant portion of law. That has not been done. They are sitting over. So therefore, Lordship, the Honorable Apex Court itself has been giving the award in different heading. There is no bar. Even in Sarla Verma's judgment, Lordship, the judgment is not with me. Perhaps in paragraph 13, it is held that Lordship, the 1/3 that is mentioned in Schedule 2, that can be varied depending on the situation and as well as dependent. So that is also the paragraph probably Lordship 13 in Sarla Verma's case. The judgment is not with me. So paragraph 13 says that even in 1/3 that is also not fixed. That is inflexible. So depending on the situation. So my humble submission is the tribunal has rightly held that amount of rupees only 10 lakhs Lordship. The person who was of 35 years old in 2014. And trial court has here only 3,000 per month, whereas he was a driver Lordship of his employer. So only 3,000 has been considered as an income. That has also not been challenged by this the respondent because Lordship, they are very poor. They do not have any Lordship position to come to the High Court challenging the order tribunal. Since the learned friend has challenged this order Lordship, we have to appear before the Lordship. So Lordship, there is nothing to interfere with the findings of the tribunal Lordship. That may be a fair Lordship, humble prayer Lordship.
I'll now substantiate judgment, Lordship. Why this is a case where retrospective application, Lordship? This is the amendment, Lordship. This has, even before this amendment, Lordship, 2019, this 163 was amended.
But this is of 2014, no? This accident is of 2014.
Yes, Lordship. Yes, I'm coming to that, Lordship. Even before this amendment, Lordship, this had become a retrospective provision. Lordship, this is the amendment. This is how this amendment is brought about. Lordship, the word that was used is substituted. And I'll come to the year of significance of substitution. What is the significance of the word substitution? So this is the notification. The Ministry of Transport and the Highways has issued a notification dated so. In exercise of the powers conferred under subsection 3 of section 163A, the Motor Vehicles Act, the central government, keeping in view the cost of living, hereby makes the following amendments to the second schedule to the Act, namely, in Motor Vehicles Act 1998 for the second schedule, the following schedule shall be substituted. The notification is the following schedule shall be substituted. This is the notification.
But you see, there are so many cases which have been dealt with and decided in this manner. Like the
I'm just coming to the maybe there are several judgments. I'll come to all those judgments. This is the amendment actually. Lordship may see. We can't go beyond the amendment, beyond the act, Lordship. Whatever some judgments might say, Lordship, but this is the act. And the act says it's amendment substitution. And the difference is the various interpretations of the Supreme Court, Lordship. What is the significance of the word substitution? If an amendment is brought about by substitution, what is the impact of it? Whether it becomes prospective, retrospective. Lordship, it is a very subtle judgment. This is one Lordship, it's three judge bench decision, Lordship, full bench. This is Jile Singh versus the state of Haryana. It, in para 24-25, Lordship, it has distinguished substitution from superstition, other ye. So what does actually substitution mean? There are also various other judgments, Lordship. All these judgments go to show whenever there is an amendment by way of substitution, then it just means that previous amendment has to be totally replaced by the new amendment. And it is taken, keeping in view the cost of living. This amendment has been brought in for the benefit of the people.
Yes.
This Parliament has noticed this. When this was the
This
cost
petition
of
was
living.
earlier filed under section. This petition was earlier
Well,
filed under
section 163A.
Okay.
This amendment is related to 163A.
Hmm.
Only after that the whole act was amended. Now it has become 164. So it can't say the new act doesn't have. It's the old act. Under the old act, this was amended. We are not talking of the new act, Lordship. New act has simply brought in that, modified that 163A, has brought in it as a 164. Lordship, our High Court itself, Lordship, I don't think in that case, if we have to follow the High Court also, this Guwahati High Court, Lordship, has already decided
This
this.
was filed under 163A.
Lordship,
So how much will you get under 163A those days?
Sorry, Lordship.
163A.
Yes.
This is not under 166.
No, 163A, Lordship. It was 163A. Now, only question is what my learned friend is trying to convince Lordship is that that if a law is amended, whether the amendment law will give a retrospective effect or prospective, that is just settled law.
That is
So
right.
what I'm submitting is that if there is no specific clause in the Amendment Act that the law will be applicable retrospectively, then this honorable any court has no jurisdiction to give retrospective effect without having any clause in the amendment. If there is an amendment in the amendment clause, there is a clause that it will give retrospective effect, then only it will give retrospective effect. Otherwise, it will always prospective. So it is very much settled, Lordship. If necessary, Lordship, I have the loss of judgment. I will provide it even after during the course of the day. There is no question of law. So this is the core issue. What my learned friend is submitting regarding 5 lakhs. Amendment Act is provided 5 lakhs. He is trying to say substitution. Substitution and amendment is different issue. So substitution cannot be treated as amendment. That is different issue. I will not go into it. So only if there is a clause in the Amendment Act that this law will give retrospective effect, then only the Honorable Court has a jurisdiction to give retrospective effect. Otherwise, every law passed by Parliament as well as state legislature has to be given prospective effect. That is law is settled, Lordship. That much less.
Let's say this notifications, it uses the word amendment.
Notification and law is different issue. Yes. Notification is different issue.
No, notification talks of amendment. Lord. So I'll read out the notification. I don't know what is the confusion here. Central government keeping in view the cost of living makes the following amendments, and the central government has been empowered by the Act to make these amendments, Lordship. It's a derivative power of amendment of the Act. The Act provides the central government to make necessary amendments, empowers the central government. Accordingly, central government has made this notification and is that hereby makes the following amendments to the second schedule of the Act. Where is the confusion, Lordship? It very clearly says makes the amendments to the second schedule of the Act. Now, that word that has been used, the following schedule shall be substituted, Lordship, in a case where no such, there is ambiguity, whether it should be retrospective, then one will go by the, it's prospectively applicable unless it is specifically spelled out. Here, when amendment was made with the object to give benefits to the people, taking into account the cost of living. So it has to be retrospective. By the very nature of the amendment, it is not retrospective. It is meant to give benefit to the people. And the word, they could have used any other word. Why substitution? And the various words that is used to bring in amendments is discussed in this judgment. Lordship, there are other judgments. All these judgments, Lordship, I'll give you all
Let
these
us
judgments.
see, this was brought to the notice of the trial court. Tribunal.
That was Lordship, Lordship, this decision was taken, this decision was dated, who dated decision? It came in May 2018.
Hmm.
The judgment was dated, Lordship. Even if it's there, when it's retrospectively applicable, Lordship, it is retrospectively applicable.
No, you
It
see,
is 2015, months before that.
before the amendment, how the court will come to know?
That's what I'm saying, it's retrospectively applicable.
Oh. So you cannot say that the court has.
Now, Lordship, even if, I'll come to this point, Lordship. Even if this Lordship does not, but there is a judgment of this High Court. I think Lordship, this court would be bound by that judgment, this Bijoya Bhuya. This is the judgment, Lordship. Bijoya Bhuya. This case was also decided, this is a case, Lordship, of before amendment. Judgment and award dated 2014. The total award was, Lordship, for 16 lakhs 19,000. It was, Lordship, this year at 5 lakhs. Modified to 5 lakhs. Here the award was, Lordship, may see 16 lakhs 19,000. Page 1. And Lordship may come to this award was, is again. This was decided after the amendment. 31/10/2018.
Let us read the judgment then.
This judgment?
Yes.
Yes, Lordship.
This judgment, let us read it.
Lordship,
Have you given him a copy of the judgment?
I have not got a copy. I can give a copy. No,
He'll have to go to it to answer this.
Then Lordship may take it on Thursday, Lordship, regarding this issue.
Yes.
Applicability of prospectivity or restorative. I will satisfy the court.
Thursday or next week?
Not that next week.
I'll give today summary, Lordship.
Today I have a problem fixing dates.
No,
The
next
other
week.
dates are not with us. In the afternoon, we'll have those dates.
Yes.
Palani. Thursday keta case আছে someone? Keta আছে Thursday? Seven already fixed. Not on Thursday. Already many
Next
cases are fixed on Thursday, maybe next Tuesday then.
Lordship.
Next Tuesday, we can fix on next Tuesday. আর আজি দুটা দিলো না নাই দিয়া না নাই এই নম্বৰ দি থৈ দিবা দেই নম্বৰটো দি থৈ দিবা কালিও আনি থৈ দিবা ঠিক আছে
On next Tuesday, Lordship.
on next Tuesday.
Next week.
Oblige, Lordship.
You give a
Oblige.
copy of the judgment.
Lordship, I have
I think
got
this
it.
is relevant.
Copy I have got it.
Mir Arfaz Ali, Justice Mir Arfaz.
Lordship might be Lordship because of it. It may be per empirium also, Lordship, because the law is settled by the apex court regarding prospectively and restoratively. I am very much sure, Lordship, regarding this issue.
You will reply?
Lordship, I will
You
reply.
get a copy of the judgment?
I have
you
got it.
reply, Yes.
Oblige, Lordship.
Please leave me, Lord.
Just a moment, just a moment. Our learned counsel, Mr. R. Goswami for the insurer and learned counsel Mr. J. Gupta for the claimant. List this matter on 3rd February. এইটো ইয়াতে তুমি মোক ক'ত পাইছিলা সঞ্জয় মেধি কোৰ্টত পাইছিলা ন তুমি মোক ক'ত পাইছিলা সঞ্জয় মেধি নহয় হেৰি ইয়াতে হেৰি তাৰপিছত সুৰানা ছাৰৰ তাত পাইছিলা ন নাই পোৱা নাই আচ্ছা তুমি এইটো এনেকে পিন মাৰো যে তুমি জানা ন সেইটোৱে মই সেইটোৱে ক'বলৈ বিচাৰিছো Yes.
Lordship, I missed the item number 14, Lordship.
Item number 14.
Only my presence may kindly be solved.
Oh, item number 14 কোনবা আছিলে কোন স্লাইড আৰু 14 তা কৈ দিবচোন এও আহিছিলে বুলি
My presence may kindly be.
এডভোকেট আহিছিলে বুলি কৈ দিবা এপিলেন্ট না বা পেটিশনাৰ
Yeah, Ala Korala. Much of that.
applicant হা কৈ দিবা all right we'll record your presence
Item 20.
So in this matter, I am seeking 1 week time, my lord.
1 week's time you have any objection
My lord.
he has
Well,
objection.
I have only objection, my lord, he has not paid the, my lord, area amount. to
item
the
number
wife.
কিমান
20, my lord. Kindly fix a date, my lord, for hearing.
Now, my lord, I am saying, even they have gone with the execution proceedings, the execution order was there in my I'm a BSF constable, Lordship. And the execution warrant went to my commandant office and I've been regularly paying thereafter, Lordship, this is my instruction.
You let
Now-
him produce on the next statement.
No, that order I cannot because that was communicated to the commandant only. That was not communicated. I was only directed to pay. And he has given me the screenshot of the Google Pay by which he's paying that. So that I'll bring on record. Now, my lord, two important questions because I was unwell. That is why, my lord, I could not do the hearing. First part is that, my lord, Pendle Light under section 24, the case was disposed of. And the earlier council was different who filed this application. I have been engaged thereafter only on. So, Lordship, whether the revision will be maintainable or not, I'll need to address on that point. But
Okay.
but that judgment I've seen two of the judgments which says that if the right of the parties is finally decided in an 24 application, then revision will lie. If it is
Yes, yes.
partly decided.
I have come across this type of argument.
Yes,
earlier.
so my lord,
We'll
this
decide.
I'll so for a week only,
Yes,
my lord,
yes.
only for a week.
And
Because I
fix a
need-
date, my lord.
You give that Google payment
Yes,
screenshot.
Yes, on the next day, on the next day.
On the date of
That
hearing.
Council Mr. A. Tiwari is present. A.K. Tiwari, no, A.
Eighth
Tiwari.
Tiwari, my lord.
A. Tiwari is present for the petitioner and learned counsel Mr. P.J. Sukiana is present for the respondent, full stop. Learned counsel for the petitioner has prayed for argument. An objection has been raised against praise for adjournment, prayed for adjournment. An objection again has been raised against the adjournment prayer. Full stop. For interest of Duchess, list this matter positively for hearing on
3rd of February, my lord, if possible.
3rd of February.
Because my
Okay.
lord, order dated 21/12 says that ki initially the point was taken by my lord Justice K.R. Surana, my lord, that the parties will deliver their arguments on the point of maintainability.
Yeah.
But that on that count, the
You
matter
do
did
that.
not proceed. The matter did not proceed on that, my lord, but subsequently, my lord, the matter was fixed for hearing.
Yeah.
The earlier council did not made any because he was the council then, while this point for maintain. Only since I have been engaged newly, your honor, so.
You can raise the point of maintainability at the argument stage also, no
Yes.
problem.
I'm obliged, lord. I'm
Obliged.
obliged.
Otherwise, matter is.
Ready? Both the parties are ready for hearing?
My lord, otherwise matter is relating to specific performance of contract.
Yes.
So may I pray and with consent with that other side.
Hmm.
If the matter is sent to the mediation, then we can try if there is any possibility.
Is there any possibility? If there is any element of compromise settlement,
That I have to take instruction from my.
he'll have to take instructions. Okay, then you obtain instructions. Next week we'll fix a date.
Right.
Or this week, within this week, short কেইটামান কম কেছ থকা দিয়াচোন চাই পেলাই কম কেছ থকা ডেট এটা দিয়াচোন Learned Counsel Mr.
DK Nath.
D.K. Nath is present for the appellant.
Appellant.
And Learned Counsel Mr. R. Sharma,
Awesome.
Dr. R. Sharma, no? Dr. R. Sharma is present for respondent number 1 and 2. So it is submitted that both the parties will take instruction if there is any element of settlement relating to the performance of contract.
Right.
First of list this matter on 13, 30, Tuesday.
Yes.
On 30. Yes.
Okay.
Thank you, Lordship. Lordship, in this matter, Senior Counsel Mr. T.J. Mohanta appeared, Lordship. He has some difficulty to the Lordship. He has for
Yes, with your
infection,
Lordship, I made a mention for listing of this matter on last occasion also, Lordship. Last occasion also, they have adjourned the matter, Lordship. I prayed for an upgradation. At that time, they said that they have some difficulty.
Who is Senior Counsel?
T.J. Mohanta, Lordship.
Lordship, in this
Yes,
case, what
having
happened,
some
Lordship,
effect,
I am for
Lordship.
the plaintiff and I filed an injunction petition. Injunction was granted by the learned trial court, directing the appellants not to disturb in my peaceful work, Lordship. I am the lessee of a brick clean industry, Lordship. Brick clean industry was taken on lease, Lordship.
You want a change of dates? You want dates to be changed?
No, interim to be continued.
Okay, okay, Nikita. Yes. Interim order shall remain in force till the next date.
So injunction was granted in our favor, Lordship. That order was stayed. For a moment, Lordship, what is the injunction order? Only for that, only your Lordship can modify that. This interim order passed by this court.
She won't be able to.
No, Lordship, I am not for arguing for the final disposal. Only I want to modify that the interim order passed by.
Lordship, they have not filed any application for modification.
No,
of the-
Lordship, for final disposal, I am praying for final disposal, Lordship. For that only, I have not filed any modification application, Lordship.
This is for hearing only.
Yes, Lordship,
And
already
this is-
admitted matter, Lordship.
Not
Today
yet.
morning also, there was another matter of TJ Motor.
Lordship,
So
may
I
kindly
passed
see-
the.
Lordship,
Passed the
Lordship
order
may
fixing-
accommodate. I am not objecting to that prayer, Lordship. I kindly see the order passed on 27/11/2000.
Actually, we have to hear both sides and she won't be able to counter
Lordship, that
counter
I,
you.
Lordship, that I, Lordship,
Because
admit,
the
but
brief is with her senior, she won't be
Lordship,
able to counter.
the matter will be argued by my learned senior friend, that I am not objecting. Only your Lordship kindly see 27/11/2025. The matter was not yet admitted, but it is fixed for hearing. So my only prayer before your Lordship, next date may be fixed and it is specifically may be recorded that matter may be listed in admission column.
No, Lordship, matter was admitted, Lordship. As per order to the 3/11/25, appeal is admitted, Lordship.
Oh, actually,
3/11/25, Lordship.
Oh, Lordship, that order I
Admitted.
have,
Yes,
Lordship. Then Lordship, and date may be fixed so that I can modify that order, Lordship, for final disposal. Because we are the plaintiffs and injunction order was passed in our favor, Lordship. That order was only stayed by this court, and injunction order says that, Lordship, we were allowed to work in the bricklane industry. And that order was
I
stayed,
think I have passed the order.
no, Lordship,
No, no.
by some other court, Lordship.
Okay.
Only the thing is that, Lordship, the appellants are now entered into my bricklane industry and they are selling my properties, Lordship. But this interim order says only stay of the trial court's order. And trial court's order is that,
I
Lordship,
know, these allegations are serious, but what to do?
For that only I am praying for final disposal, Lordship. No more adjournments on next date, Lordship. As already they have taken 2 adjournments on last occasion, though it was not mentioned, my learned friend will agree, they have taken adjournment on last occasion, Lordship. I prayed for an Lordship upgradation of the matter. At that point of time, they said that they have some difficulties, so I agreed. And this matter was immediately filed on reopening today, 27/1, Lordship, for disposal. So your Lordship, kindly consider my prayer on next
Okay.
date, no more adjournment. Matter
Already
is,
passed one similar order in another case
Yes,
Lordship.
for TJ Mohanto.
Yes, Lordship. Yes,
Learned what is your name?
PP Das, Lordship.
PP Das. Learned Counsel Ms. PP Das is present on behalf of Learned Senior Counsel Mr. TJ Mohanto and has prayed for adjournment. First of Learned Counsel Ms. R. Chaudhary has raised serious objections stating that
On
the-
21/1 also they have taken adjournment.
stating that in the guard of the stay order, the petitioners have encroached into their land and they have been
Bricklane industry, Lordship.
into their brick clean industry and they have been manufacturing bricks
They are selling my
and they are
properties.
selling bricks from the
My industry,
the
sir.
respondent's property, full stop. Considering the submission, this case is fixed positively for hearing on convenient date for both sides.
Lordship, 3rd of February, it's a
3rd
hearing
February.
date, Lordship. 3rd of February, Lordship.
After 3rd, Lordship, and on 12th, Lordship.
Okay, on 12th then.
Then, Lordship, on 2nd February, or it's a Monday, Lordship.
No, on 12th. Otherwise, they will again take adjournment.
Lordship. Then 5th of February, Lordship, as because Lordship. Sir, nothing evening.
He may go to Delhi.
12th February, okay. 12th February positively without fail.
But Lordship kindly modified that they may not violate the order of.
No, no.
Lordship.
How can modify?
Lordship, interim order, I don't think.
Interim order shall remain in force till the next date. please, without passing any order, please don't take away their bricks.
Already we have, they are,
This is the allegation, what I'll, this,
they are the owner, lordship, that is admitted, they are owner and we are the lessee, lordship.
Cases are come out from the case, Lordship, now.
That is the fact, lordship, they are the owner and they already leased it out to us.
7 lakh
lordship.
rupees has agreed amount per year. After paying 10 lakhs, without paying, they have abandoned that big industry by taking all my FIR. For that, I have filed a FIR, Lordship.
okay, okay, all right.
Obliged, lordship.